prospective employees based on their wage history or seeking the wage history of a prospective employee. And Bill 25-0026, the Pay Range Act of 2023, was introduced by Council members Trayon White, Louis George, Pinto, and Nadeau. And this bill would establish requirements prohibiting employers from posting a job advertisement without including the minimum and maximum salary or hourly pay information. I look forward to discussing these bills today because the consistent lack of transparency relates to wages and benefits, perpetuates gender and racial wage gaps. Creating transparency will correct the consequences of these disparities, such as helping to reduce bias during the negotiation process and creating more equity. I look forward to hearing from all of our public and government witnesses regarding these important bills. I'll ask that our witnesses keep their remarks to 5 minutes to allow us all the opportunity to be heard. With that being said, I want to note that the entire written testimony that is provided to the committee will be a part of the record. So if you have not submitted your testimony, please email it to seal@dccouncil.gov. Seal, that is CEAL @dccouncil.gov. The hearing record will remain open until Saturday, the 24th of June at 5 p.m. At this time, I want to recognize, I see one of my colleagues, Councilmember Henderson, and like to give her an opportunity to make an opening statement. And good morning and welcome.
Good morning, Chairperson Bonds. Thank you so much for holding this hearing today. I was proud to reintroduce the Fair Wage Amendment Act this council period with the intent of leveling the playing field for women, Black and Brown residents, and seniors who are seeking employment in the district. The purpose of this bill is to prohibit an employer from pre-screening prospective employees based on their wage history or seeking the wage history of a prospective employee. You mentioned some of this, but when looking at the data, it became clear that this was an issue that needed to be addressed. So according to the Census Bureau and the National Partnership for Women and Families, women in the United States are paid 83 cents for every dollar paid to men as of December 2022. The wage gap in the District of Columbia is marginally wider than the national gap, with women making 81.9 cents for every dollar paid to men. When race is taken into account, the divide in the district is even starker. In 2021, Black women made just 51 cents for every dollar a white male made in the city. And finally, Census Bureau data reveals that the gender pay gap widens as women age. That monthly earnings decline faster for female seniors employees than male, and that over the course of a 40-year career, the Black women in the district will make about $1.98 million less than white men because of these earning gaps. We saw that the pandemic further exacerbated this divide. And so, in some cases where women had to leave the workforce altogether to care for children or to care for family members as childcare slots disappeared. The district cannot tolerate wage discrimination, and it is imperative that this government adjust the mechanisms that hinder women from earning equal pay for equal work. I look forward to the discussion today and working with my colleagues on the council to pass these bills and renew our commitment to pay parity for all district workers. Thank you, Chairperson Bonds.
Thank you very much, Councilwoman. Do we have any? Okay. All right. So perhaps some of our other colleagues will join us later, but we're going to move very quickly now to hearing from our public witnesses. And we will start with Dahae Kim. She is the State Policy Senior Counsel for the National Women's Law Center. Welcome. And you can begin when you're ready, Ms. Kim.
Good morning, Chairperson Bonds and members of the committee. My name is Dahe Kim, and I'm the State Policy Senior Counsel at the National Women's Law Center. For decades, the Law Center has been working closely with state policymakers across the country to strengthen laws for closing gender and racial pay gaps. We're excited that council members have introduced legislation to tackle what studies have shown are among the key drivers of gender and racial wage gaps within workplaces, relying on salary history and pay secrecy. When employers rely on salary history to set pay, they force women to carry pay discrimination from job to job. If an applicant previously worked in a female-dominated profession where pay is lower precisely because women do the job, then women's work is devalued, and the new employer sets her pay based on that prior salary, the pay discrimination that applicant faced in her previous job will follow her. And when employers automatically screen out or compare applicants based on the assumption that an applicant with a lower salary is of lower quality than an applicant with a higher salary, women and people of color lose out. And as Chair Bonds discussed earlier, salary history bans are a proven policy to close wage gaps. In our written testimony, we will also include recommendations for tweaking the salary history ban language to provide greater clarity to employers and avoid certain loopholes that have been identified in the process of working with other states on this type of legislation. Notably, it is important that the bill clearly prohibit relying on salary history to set pay, and that employers only be allowed to seek to confirm an applicant's salary history if it has first been voluntarily provided by the applicant. However, a salary history ban is not enough. We've heard from some states that when employers no longer ask applicants for their salary history, they ask applicants for their salary expectations, a practice that can also lead to wage gaps arising, as some research shows women, and especially women of color, often ask for less compared to their equally qualified male counterparts. Fortunately, research also shows that when applicants are clearly informed about the context for negotiations, including the typical pay for the position, these gender differences in negotiation outcomes diminish. Moreover, pay discrimination thrives in the shadows. Pay range transparency provides clarity to applicants and shines light and accountability on the pay setting process to help employers more efficiently, effectively, and fairly hire and set pay. Salary history bans and pay range transparency also help businesses. Ending reliance on salary history can help businesses attract and retain a diverse workforce by ending a practice that is known to limit businesses' talent pool, hurt their brand, and drive the best applicants away. Pay range transparency also helps employers attract and retain talent. Survey after survey has shown that an overwhelming majority of job applicants prefer to work at a company that discloses pay information, and many applicants won't even apply for a position if the posting doesn't include the pay range. And a recent survey by the Society for Human Resources Management showed that 70% of employers who include pay ranges in job announcements found that doing so led to more applicants applying, and it increased the quality of applicants that they were getting. Not to mention that pay range transparency promotes employee trust, loyalty, and productivity. Basically, it helps businesses avoid wasting time and money sifting through applications and interviewing applicants who wouldn't accept the position because the pay doesn't align with their expectations. And the time and cost savings particularly benefit small businesses who often do not have HR teams. So unsurprisingly, smaller employers already tend to post ranges more regularly than larger employers. And as a result, we encourage the council to ensure that any salary history ban or pay range transparency ban that passes cover all sizes of employers. And given all these benefits and ease of compliance, it's not surprising that in Colorado enjoyed a higher compliance rates in the first few months of its pay range transparency law going into effect. And there are a multitude of states passing bills like the one we're discussing today. 60 states like Maryland, Delaware, and New York already have salary history bans, and DC already bans its agencies from asking applicants for salary history. And 10 states, including New York, Washington, and Illinois, have passed pay range transparency laws. And we also encourage the council to ensure that the protections in each of these bills include a mechanism for the agency to initiate its own investigations, as well as a private right of action. Thank you for your time, and I am happy to take any questions.
Thank you very much for your testimony. Next, we will hear from Abel Amini, public witness. Good morning, welcome. We can begin.
Good morning. Good morning, Chairperson. My name is Bella Mene, and I'm happy to testify today on these three bills. I want to thank you, Chairwoman, for this opportunity and for bringing these bills forward. I was an advocate for, doing an update of the Wage Transparency Act last term when a hearing was held on one of these bills, an earlier version of one of these bills, and I did encourage combining these into an omnibus that would advance them together, and I'm hopeful that is the direction we're heading. I want to testify first on as a person that has worked for years in the restaurant industry, and how important it will be to increase wage transparency, specifically for the restaurant industry. When I worked in restaurants, applying for a job was a difficult thing, and oftentimes you had no idea how much you were going to be paid after being hired. The application process would often ask you about your previous pay scale, but would never state how much you would be paid. You would go through an entire process of an interview, securing transportation with the little money you have, to go to the place to interview, to go through the stress of interviewing, only to find out afterwards that the pay is very measly and not going to cover your expenses. And oftentimes, when they asked what your previous pay was, there was internal pressure on yourself to give a lower number, with the hopes of making yourself more likely to be hired. These are all things that we are trying to address today, and these three bills combined will get us a long way there. I do want to comment about a few specific things in a few of these texts. I do notice in your version, Chairperson Bonds, that there is a 25-person minimum employees. I am very concerned about that because it would most impact restaurant workers. Typically, 25 or below is a round amount of people that are employed by restaurants. So by placing this minimum, you will be excluding from the benefits of this legislation the vast majority of restaurants in DC. And it is often said that the people that work in restaurants are Black women, often Black and brown women are often work in restaurants. So by excluding those that would that employ less than 25, you will be undercutting a major benefit of this bill. I recommend that there be no minimum. As the previous witness said, most often small employees actually are more likely to list this already and are already practicing it, and it will not be an additional burden. And in fact, it might cause more confusion to place a minimum. And so people won't even know, like, what if I have 22 employees this year and I hired a few more? Like, it's going to create more problems than it solves. The other thing I want to focus on is enforcement. Thankfully, it looks like we're going in the direction of amending the wage transparency law, which already includes enforcement mechanisms. But one thing I want to emphasize is that we have a lot of labor protection laws in the books, but many of them are not enforced. Recently, I think a report was released that showed DOES often gets reports directly from the employers saying that they are underpaying their employees below the minimum wage, but don't do much about it. So I would like to recommend that you ask the OAG, if they are testifying later, how you can craft this legislation to make it easier for the OAG to bring class action suits against employers so that this legislation has some teeth and actually is effective in what it does. So if what is needed is some language giving the AG specific class action powers, I would like to encourage that. Thank you very much for this opportunity. And I am so glad to see this legislation moving forward. Thank you.
Thank you very much for your testimony. And all right, our third witness is not present, so we'll just use this opportunity to ask just a few questions. We'll do 5 minutes. I suspect might be adequate. Mr. Amini, thank you for making situations that many who are looking for employment real. Thank you for your testimony. You know, when the 2014 legislation was drafted, it was thinking more about those who are trapped in, you know, some of the employment opportunities that were offered by the larger companies. And I agree with you. We're probably at a point where we need to look at every employer. Things are tight in the economy, so it probably does make sense. So thank you for that comment, which we want to take under advice. Not to say that one individual gets to influence, you know, major legislation entirely, but I'm pretty sure that you are speaking for many when you recounted to us the application process. That's very meaningful because it does make sense that when you apply, if you don't have an idea of what the salary is, you're not told, you do want, if you want the job, you really are going to do everything you can to get that job. And that really means that you might sacrifice a little bit, but it would be far more wholesome if you had an indication of what it would pay you and the benefits and all of that. And that's where we are trying to go. When you speak of the application process, are you suggesting that the application process may be the location where information is provided to a prospective employee about the salary range, or are you thinking it should be more advantageous to receive that information before you actually apply, like through an ad or what have you?
Yeah, actually, there was another government witness that submitted testimony describing, I believe it's the Human Resources Office, that describing how district agencies handle this. And I think it serves as a very good model. If you look at any job posting by the district government, it always includes how much people are expected to pay. And not only that, it includes much of what you included in your legislation about benefits, healthcare, and all the other things that come with that job. And to also speak about one thing, to uplift something Ms. Kim said, it is not only enough in the version of in Councilmember Henson's bill to bar people from asking previous employees how much they were paid in previous employment, but also to bar asking for how much people expect to be paid, which is another version of a question that appears in applications. But as far as where to post how much people should expect to be paid, I think it is very important to include it in the job posting originally. And that's what DC government does it for job postings in district agencies. And I think that is a very good practice that even before someone opens the application in the job posting, it should include all the pay included and the benefits as well.
Thank you very much. Ms. Kim, I have just a few seconds. Wanted to ask you, could you really talk a little bit about the plight of those who apply to small businesses?
I'm sorry, I don't think I heard your question fully.
Oh, okay. What I'm asking, you mentioned reference to small businesses, and I wondered if you have some examples that you can give as to what happens when an individual is applying to a small business. Let's say business with 3 employees as an example.
Sure. Well, what we've been seeing is that a lot of small businesses are already tending to share ranges. If they don't have an HR department, which many small businesses do not, it actually helps save them time and its related costs.
All right. Okay. Thank you so much. I'm trying to stick to my time. Councilwoman Henderson, I'll give you your time.
Thank you so much, Chairperson Bonds, and thank you to both of you for being here to testify. I wanted to ask, I guess, Abel, you might have, I think, clarified this, but I think, Dahe, you mentioned in your testimony around the expectation piece as well. So is the recommendation that that also be not a question that can be asked in the application? I've definitely gotten that question in interviews, right? As a like, what are you expecting here? Just to sort of see if both parties are aligned.
I will let Ms. Kim answer that.
Sure. Well, I think it's important that the salary history ban are structured to allow for the free flow of negotiations.
Okay.
However, it's important, but that is why pay range transparency is important to sort of combat this expectations question.
Yeah, I think if you have the pay range, going up front. But I think, Mr. Amini, you mentioned as well, right? I think for a lot of my friends, you hate to go through the whole process. You've either had to do the writing sample and you did the writing test or the memos, et cetera. And then you find out what the pay is and you're like, I did all this work and this is not even going to work for me at all. And so I think the recommendation of all of these working in concert with each other, the transparency plus not asking for the salary history, I think will help improve this altogether. But I don't have any further questions. Thank you guys so much for being here. Thank you, Chairperson Bonds.
Thank you very much. I think we've got it. We hear you loud and clear, and we're looking at the data. And I think our small little effort today is a determination that we are going to make some changes. So thank you very, very much for taking time out and joining us for this important hearing. Thank you.
Thank you very much.
Thank you.
Now we have an opportunity to hear from our government witness. We're going to hear from Graham Lake, who is the Chief of the Office of Attorney General's Workers' Rights and Anti-Fraud Section. So, Mr. Lake, will now swear you in if you raise your right hand. Thank you. Do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete?
I do.
All right, thank you. And you can begin when you're ready.
Good morning, Chairperson Bonds, Councilmember Henderson, other members of the council, staff, and residents. I'm Graham Lake, Chief of the Workers' Rights and Anti-Fraud Section at the Office of the Attorney General, or OAG. I'm pleased to appear on behalf of Attorney General Brian L. Schwab to testify in support of the 3 pending bills that would expand protections and advance equity for workers in the district. While OAG has submitted in its written testimony some recommendations I'm going to stick to the portions of the testimony that will allow me to meet the time constraints that the committee has asked that we follow. So Attorney General Schwab is committed to protecting workers' rights while fostering an environment where law-abiding district businesses can thrive and where equity is promoted. Since gaining authority in 2017 to enforce the district's wage theft laws, OAG has secured over $18 million for workers in the district by bringing investigations and lawsuits against employers who violate district law. As you heard, as we all heard in Chairperson Bonds' opening statement and in Councilmember Henderson's opening statement, as well as the public testimony, gender and racial disparities in income and wealth are a pressing and persistent problem both nationally and in the district. Now, we all heard some of the statistics, but they're striking enough that it's worth going through again. According to March 2023 data from the National Women's Law Center, women working full-time currently earn 84 cents for every dollar that men earn nationally. Consistent with that national data, in the district, women working full-time earn 85% of what men earn. This disparity is wider for women of color. Black women working full-time in the district earn 52 cents per dollar that white men earn, and Latina women working full-time in the district earn 64 cents per dollar that white men earn. Income disparities also exist along racial lines independent of gender. Nationally, Black workers earn 76 cents per dollar that white workers earn, and this disparity is heightened in the district, where Black workers earn 61 cents per dollar that white workers earn. Similar inequities exist for Hispanic, Latino, and Native American workers. The trio of bills that are under consideration by the committee would play a critical role in combating these longstanding income inequities. The Pay Range Act and the Pay Scale and Benefits Disclosure Amendment Act of 2023 would both require certain employers to provide applicants with the salary range that the employer believes in good faith it would pay for the advertised role. These policies are an important step toward improving negotiation and bargaining power for women and people of color. The research on this topic is clear. Women and people of color experience worse outcomes in salary and benefit negotiations. However, salary range transparency policies help to level the playing field because transparency provides applicants with information that will allow them to engage in informed negotiations based on the value of the role instead of their prior income or prior experience. Recent studies demonstrate the practical benefits of these policies, showing that transparency policies in certain industries have significantly reduced the gender pay gap. In fact, some research suggests that the gender pay gap can be reduced by up to 40% with broad pay transparency. The Fair Wage Amendment Act, for its part, is also an important step toward ensuring that workers are paid what they deserve. This bill would prevent employers from asking about and or relying on a job applicant's wage history throughout the application process. Recent research from the Harvard Business Review found that the use of salary history is a key driver of creating and preserving gender wage gaps. It is easy to see why women and people of color are systematically underpaid, so relying on applicants' prior earnings to set their future salaries perpetuates systematic inequities in pay. Since gender and racial wage gaps often stem from overt discrimination, unconscious biases, and other societal factors, relying on applicants' prior salary can make it impossible for them to break out of the cycle of being underpaid. And research from other states suggests that circumscribing employers' reliance on salary history can help narrow wage gaps. For all these reasons, OAG supports the Fair Wage Amendment Act as a tool to address longstanding wage gaps. Additionally, enacting these bills will ensure that the district keeps pace with other states, cities, and localities that have implemented similar bills. 8 states and 6 cities or localities have implemented salary transparency laws, and 16 states and Puerto Rico prohibit employers from relying on salary history in the hiring process. With these bills, the district has an opportunity to maintain its commitment to being a national leader in policies that protect workers' rights and promote equity. Now, we're happy to provide the recommendations in our written testimony and not necessarily go through it here, but because Mr. Amene had mentioned our enforcement authority, I did want to touch on that as part of my testimony. Among the trio of bills, the only bill that would provide express enforcement authority to OAG is the Pay Range Act. And while OAG has robust general enforcement authority, we do believe that the express grant of OAG enforcement authority with respect to all of these wage transparency issues would help streamline our enforcement by avoiding unnecessary disputes over OAG's jurisdiction to conduct investigations and ultimately bring enforcement actions when necessary. I'm happy to answer any questions that the council members may have.
Thank you very much. Mr. Lake, can you elaborate a little bit more on the enforcement aspect and how you see our government being able to implement enforcement? I know we passed many laws, and we say that, an entity shall or must, and somehow it doesn't get implemented. So what is your recommendation, if you have one at this point?
Yeah, so particularly in the workers' rights space, the wage and hour space, we have collaborative and productive dual enforcement between the Mayor's Department of Employment Services and OAG. Here, the Wage Transparency Act of 2014 currently is read to address certain express authority to the mayor. Now, as I mentioned, our office has very broad general enforcement authority. So, we think we'd have the ability to engage in enforcement in this arena anyway, but it would help streamline enforcement and avoid disputes over jurisdiction to expressly provide in the transparency bills that OAG has enforcement authority with respect to these matters.
All right, you mentioned in the Pay Range Act, I believe, that is of the three bills we're examining today, that's where you do see reference to enforcement. And looking at that that bill, what would be your role? I mean, reading where you are actually named in the bill, that is your anti-rights and anti-fraud section of the OAG office. But how would that work? Let's say I am an employer and I have violated an applicant's rights. What happens next in getting this to you to adjudicate?
So I think maybe a good way of addressing that is just to talk about how it works in some of our other wage and hour contexts. So for most wage and hour issues, we share an enforcement role with DOES, and that is largely parallel enforcement. So someone can go to DOES and file an administrative complaint with them, or they can provide a tip to our office. Frequently, those tips come in through, we have a dedicated email tip line, workers@dc.gov or trabajadores@dc.gov. And those tip lines allow us to reach out to someone who has a problem, understand it, and then where appropriate, investigate. And we have authority to investigate using pre-suit subpoenas, to take depositions, i.e. ask people questions under oath. And that's really robust and a powerful tool to make sure that when people complain about abuses in the workplace, that there's a government tools that are sufficiently strong to meet the moment. So here, in the context of this bill, again, we believe we have broad general authority, but it would be helpful to to make it express in the context of these transparency bills. And I think we have suggested some language and can suggest some language to that effect. And I should just back up as well, Chairperson Bonds, to say that our one of our other recommendations is that the three bills in a sense be consolidated into a single amendment of the Wage Transparency Act, since they all seem to be addressing the same core problems, and streamlining the enactments may help ensure that the policy is being dealt with holistically.
Thank you very much. That's certainly the direction I feel that we are moving in, and that is to have, as was said by, I think, one of our public witnesses, an omnibus bill that takes into consideration the needs as well as the modern times, so that we can be more effective at, I always say, at doing our due diligence and our governance. It's trying to strike the right balance for all of the residents of the city. So I thank you for that response. I'll ask Councilwoman Henderson if she has any questions. All right, there you are. Okay, all right, thank you.
Apologies, I had a little bit of trouble there. Mr. Lake, thank you so much for being here today. I was wondering, in terms of wage discrimination cases, does the OAG track them? Is this an issue that has come up over the years?
So we track all manner of complaints that come into our office. So I should say that matters that involve discrimination within the workplace are actually handled by my colleague in the public advocacy division of the of OAG, the civil rights and elder justice section. So there's principally my main expertise in terms of workers' rights enforcement. It falls within more of the wage and hour space, but speaking at a high level, we do track and follow the complaints that come in.
Got it. Do you think that there are any industries that should be exempt from these laws?
Happy to circle back on that. I do think, the only exemption that we've suggested is the federal government, just based on the fact that the Home Rule Act doesn't allow us to go there. But I think one of the bills had that in. The broad principles here of promoting equity, they don't stop at particular industries, but to the degree somehow we're further thought should be given to potential exceptions, we're happy to do that and circle back. But the principles here are promoting equity, and it's hard to see sitting here today that there'd be an industry specific exemption that would make sense to those principles.
That totally makes sense. But you did mention in your testimony that you felt limiting the application of these policies to employers with at least 10 employees. I'm curious why 10? I'm just, how would this, not asking these questions be of a certain burden to smaller size firms?
So we looked at that recommendation was driven in part by looking at the landscape of where other jurisdictions are. And I think the Center for American Progress has a helpful breakdown of where people are. So Washington State, I believe, is 15 or more employees. California is 15 or more. And then, of course, there are some that are fewer. So New York has 4. I think Rhode Island has 1. We looked at the initial proposal that was 25, and as an office believed that policy struck the balance too high. It's a classic line drawing issue. But again, I think it's important to try and broaden the application to the extent possible.
Yeah, I agree with you broadening the application. I'm just sort of, I'm sensitive to the concerns of small businesses on some of the things that we require. And that if you don't have a large back office or HR or those kinds of things, it can get very complicated for you. But this very simple thing of posting your salary range, not asking for salary history, I feel like are things that anyone can do. But we could work through that with the committee. The last question I have is around the application of this law to subcontractors or temporary workers. Do you all have any thoughts on that?
I think the application of laws to subcontract temporary work, it sweeps in a host of different issues, including the proper classification of subcontractors and the like. The definition of employer is quite broad and does appear to reach independent contractors. And again, I think in this context of transparency and promoting equity, it makes sense to have a broad sweep.
Thank you so much again for being here. Thank you, Councilmember Bonds. I don't have any other questions.
Thank you very much. Mr. Lake, I wanted to just sort of follow up a little bit on this, who can be excluded as a employer, and wondered if we are thinking or have some advice from you as it relates to those very small firms that are usually an individual that is set up as consultant, trading as individual. And they're looking for maybe just one additional employee. Just wondered if you given thought to that.
Thank you for the question, Chairperson Bonds. I think this does go to the policy judgment that for a threshold number of workers. And if you look at the landscape of states that have enacted these laws, again, there's a line drawing issue, but most of them do include some number limit that would exclude the circumstance that you've identified.
All right, so when I think you cited as an example, I believe New York, they set a number of 4. I believe your testimony indicated that. Is there some description of why they set that number? Was there discussion as it related to consultants or small mom and pop, corner stores, sandwich shops? Trying to get an understanding.
It's a good question, Chairperson Bond. Sitting here today, I don't know that I'm not familiar enough with the legislative history of those enactments in other jurisdictions to say the degree to which this particular question in the reasoning was clear.
All right. Just quickly, the Fair Wage Amendment Act seeks to revise the definition of employer from individual, firm, association, or corporation, or LLC, to be defined as persons. The agency mentioned that the revision would lead to confusion. Could you explain how defining the term employer as persons could create enforcement challenges?
I think the concern there is if the legislative history isn't clear, they're sitting there, an objective observer who sees that change could think one of two things. They could think, oh, the council is just clarifying and using the term persons to mean the broad set of individuals and entities that it previously had listed. That could be option A. Or option B could be to think that maybe the council meant to limit the applicability from corporate employers to just individual employers. And so absent sort of accompanying legislative history that helps clarify the intent, I think the only thing we were trying to flag there was that if the council narrows the definition, it could lead to some uncertainty about what the effect and intent of that narrowing meant to be, whether it's clarifying or actually a substantive limiting of the application.
All right, thank you. Now, the Fair Wage Amendment Act's primary objective is to prevent employers from seeking the wage history of prospective employees. However, the bill provides two exemptions where one, the employer has made an offer of employment with compensation to the prospective employee and seeks such information for the sole purpose of confirming information about the prospective employee's wage history. And then two, where the prospective employee has provided written authorization for the employer to receive the specific information sought. And you noted that these provisions would potentially create confusion regarding an applicant's ability to voluntarily disclose their salary information and an employer's ability to ask about wage history after an offer has been made. Can you give a little more explanation about this position that the OAG has taken?
I think there are two underlying considerations. One was that there are certain circumstances where you're going to have someone who's considering a job where it actually will be part of effective negotiation to bring forward a past salary that the worker themselves will want to bring it forward, and not wanting to hamper that. On the other hand, I think another consideration is just making sure that whatever exception there is doesn't swallow the rule and doesn't allow for the ability for a prospective employer to, as a matter of regular course, obtain consent as part of its process to obtain past wage history. I don't have that particular recommendation quite top of mind, but my recollection is that those are two of the considerations at issue as the council, that we'd suggest that council have in mind as it weighs the specific wording.
Okay, and one other question. How do you propose we protect employees from potential retaliation or discrimination because of wage transparency? I mean, are there any protections in place for whistleblowers who report non-compliance with the wage transparency laws? You mentioned the hotline or the tip line. Just wondered, how do you see this operating?
In general, I would have to pull back up the Wage Transparency Act to refresh my recollection about what there's already existing retaliation provisions, but there are a number throughout Title 32, and essentially they function in similar ways of defining what is protected activity and then limiting how employers can respond to that protected activity. And we think those protections generally are important because they ensure that private individuals that are exercising their rights aren't then punished for doing so.
Well, frequently when we hear from the public that there is retaliation on their job. I know I certainly hear it, and we just heard it recently as it related to the union attempting to organize itself down at a hotel in the area. And so I'm just wondering what kind of safeguards can we include in, let's say, an omnibus bill that would address that issue as we talk about wage and pay transparency?
The current Wage Transparency Act, I was just looking it up. It does currently prohibit as employers from attempting to either prohibiting or attempting to prohibit an employee from lodging a complaint or testifying, assisting, or participating in an investigation or proceeding. So there is some protection there. I do think that the way to ensure robust protection is going back to an earlier point of just making our office's enforcement authority express with respect to the wage transparency laws, because that is something that, then there's an additional avenue for protection for someone who's being retaliated against. And right now they can go to DOES, and this would also make sure there's no dispute that they can also email our workers' rights and anti-fraud section to refer any complaints about retaliation to our attention. And I would say, to the extent that you or any of your staff members receive those complaints, we certainly would appreciate learning about them, as we take the retaliation quite seriously.
Thank you. Thank you very much. We have been joined by Councilmember Matt Fruman, a council member from Ward 3, and council member, he's a member of the committee. We'd love to have your input at this moment.
Well, thank you very much, Chairperson Bonds. I came just to listen in. I think these are important pieces of legislation. I was grateful I missed much of the testimony, but read the testimony, and grateful that the Office of the OAG is supportive in principle of the legislation. Intrigued by the idea that perhaps the three bills should be brought together as one. But I take it that the OAG is substantively in support and does not have any major issues other than this question about bringing them together for consistency and the concern about the definition of employer. Is that right?
That's right. There are no concerns, and we think it's an important step to addressing an important and persistent problem in the district.
And so I think I'll leave it at that. I think it's good when we do our job well when in drafting the legislation and can win support of folks like yourself, and let's push this to the finish line. So thank you.
All right. Well, thank you very much. Thank you very, very much, Mr. Lake, for joining us today. And I will say that, and I thank everyone, particularly our public witnesses, for taking time out of their schedule to be with us on this occasion. And thanks to everyone for their contributions today. If the public has any additional thoughts or would like to submit a written testimony regarding the legislation, please email it to seal@dccouncil.gov. That's CEAL@dccouncil.gov, and it will be included in the hearing record, which will close on Saturday, June 24, 2023 at 5 p.m. The committee's next hearing will be on Friday, June 16th at 11 a.m. And it will be a public roundtable with the Department of Employment Services. So with that said, thank you all very much, and this hearing is adjourned.